We're ready whenever you are.
Please support Robert Hubbard on behalf of the plaintiff appellant Apex Roofing. I may have reserved 5 minutes for rebuttal.
Okay.
This is a first party property claim for damages arising out of Hurricane Irma. The trial courts granted summary judgment finding that the plaintiff failed to comply with several post-loss conditions. We're asking the court to reverse and remand for further proceedings.
Can I ask you what post-loss conditions you did comply with?
Well, so that question goes to the initial claim, and what happened several days after the incident, the insured.
Well, we're really here about the supplemental claim, aren't we?
Well, it's an important question, Your Honor. Okay. And that's what the Goldberg case talks about, and if you want, I'll jump right into that issue. But there has to be a distinction between the initial claim and the supplemental claim.
Do you agree there was a supplemental claim here?
No, Your Honor. Based on the record that we have and the issues, everything that is being litigated as far as damages seems to relate to the initial claim. If I could.
Well, but the initial claim was adjusted and there was a payment made. And that fact, that is included in the definition of a supplemental claim, because a supplemental claim is supplement to a claim that's already been adjusted. So tell me why it's not a supplemental claim.
Well, so our position is there is a dispute between a dispute as to the amount of an initial claim. Scope issues that the insurance company inspected, included in an estimate, and then the policy, the loss settlement provision.
Oh, and then your client hired your, or the homeowner hired your client. Why did your client take so long to not contact the insurance company and wait so long and file the lawsuit after this 3 years?
Well, he didn't wait so long to contact the insurance company. He did reach out by phone.
But he's about the owner?
Yes. So you're referring to this?
I don't know that.
Well, Your Honor, my client, the roofing company.
Yeah, that's what I'm talking about, because you're the assignee. Now you're the party in interest.
Correct. And
not Mr. Steinhook was. So
correct. And they did file suit before reaching out to the
insurance. I know, then they waited 8 months to file the $545,000 estimate.
That's correct. The estimate was not produced until they responded to the request for production. Again, I want to stress the difference in between a dispute that goes to the initial claim and then a supplemental claim for something additional. And I believe this court addressed that in the Ironwood case. In that case, this court did a good job of really distinguishing between an initial claim. There, the insured, it was a Hurricane Irma claim. They filed a claim for roof damages. The insurance company comes out, inspects the roof. They resolve the roof portion of the claim. Sometime later, there's a supplemental claim for windows and doors. Eventually, the court is addressing whether the case was right for appraisal, but the analysis was, if the windows and doors claim was an aspect of the initial claim, then appraisal might be right. If it's a supplemental claim for which a separate coverage determination needs to be made, then appraisal would be premature.
So let's take all of that and go back to the question that Judge Morris was asking you: is what post-loss obligations? Because I'm trying to figure out on the initial claim, right? Okay, so what post-loss obligations did the insured in this case fulfill?
Okay, so
other than the phone call.
Well, and I'll point the court to subsection C in the policy of conditions provision, duties after a loss. First, I want to note the lead-in language to that provision because it's really important. Forgive me for reading, but in case of a loss to covered property, we have no duty to provide coverage under this policy if the failure to comply with the following duties is prejudicial to us. So here's a list of conditions. And the policy is making clear that if the insured doesn't comply with these conditions, there's no duty to provide coverage. Among those duties, the first one is to give prompt notice of the loss. I don't think, certainly for purposes of the summary judgment that was filed, whether prompt notice of the initial claim, it wasn't an issue.
I don't think that's an issue.
Correct. To protect the property from further damage. Again, not an issue that was raised below. Cooperate with the investigation. The insured allowed the insurance company to come out and inspect. They had an adjuster there. I believe the insured testified that a friend who was a contractor was there with a moisture meter to walk around the property. And there was a lengthy discussion with the adjuster about the scope of damage.
And then there was a letter, and then there was a check, and it was end of story and silent for what, a couple of years?
If we're looking for written communications to the insurance company, there's nothing in the record from the time when the check is received until when a lawsuit.
What does the policy say about written communication as far as to expressing your disagreement?
So Your Honor is pointing to either the mediation or appraisal provision and the suit against us provision, which do both say that prior to filing a lawsuit or a dispute as to the amount, the insured needs to provide notice in writing to the insurance company.
Okay, and so was that done in this case?
No, Your Honor.
Okay.
And so, in looking at where these provisions are in the policy, that was why I pointed to the lead-in language of the duties after loss provision, because that policy provision is clear that the insurance company's coverage obligations are contingent upon compliance with these duties. Now, when we look to the mediation or appraisal provision or the suit against us provision, there isn't similar language that says the failure to provide this notice will excuse the insurance company from performance under the contract. I mean, the mediation or appraisal provision is typically in a policy for both the benefit of the insurance company and the insured. And certainly I can't point to anything in the record to say that written notice was provided, but at minimum, we do have record of the insured contacting the insurance company, expressing his displeasure with the amount of the payment. And so, whether the failure to provide written notice prior to filing suit is a material breach, it's our position that that's a fact question for the jury. When you look at the nature of those provisions, the lack of any language in the policy that says the failure to comply with these provisions will excuse any performance from the insurance company under the policy. The trial court relied heavily on the 4th District's decision in Goldberg, and it's easy to understand why the trial court might have looked to Goldberg, because it is very similar factually. The policy at issue in Goldberg didn't have the mediation or appraisal language. It didn't have the similar language requiring notice in writing in that policy. When you read all of this together, the policy would at best merely require written notice. Whether in Goldberg, the court's conclusion was essentially the supplemental claim requires a complete competing estimate. And that's where I disagree with the court's analysis in Goldberg, because essentially if a competing estimate can constitute a supplemental claim, and otherwise an insurance company is merely obligated to pay its estimate, you get into a situation where the supplemental claim almost comes before.
But isn't that the problem that you have here is there is no estimate or competing estimate that happens until well into the discovery. I mean, you have Mr. Shapiro on deposition saying he didn't even know what it was. He didn't know anything about it. He didn't even know what happened to the check. He thinks he sent it to the roofing company. So.
Well, the estimate that was produced during litigation could be used as evidence for the jury to consider as to whether the initial payment was adequate. The loss settlement provision and the Florida statutes require you.
But the insured was required to file a supplemental claim.
Well, whether the insured was required to provide written notice of a dispute or whether the insured was required to provide a supplemental claim.
But you would
are two
agree
separate
it
issues.
didn't happen before the lawsuit.
That's correct, yes.
Okay.
And
Can you tell what is, there's also a claim about living expenses. I don't really see any response to that in the answer brief. Can you enlighten me about the living expense? I guess this is a supplemental claim that you allege that they denied coverage on.
well, it's certainly a claim that was not paid. During the course of the claim adjustment process, the insured's wife, I believe, submitted several invoices for hotel receipts. There was no payment made on those, and in response to the summary judgment motion, plaintiff filed or argued that that's an additional coverage that needs to be considered and would preclude entry of summary judgment. If you read the deposition testimony of Mr. Shapiro, he testified that those were provided to the insurance company. You know, it sounds that he retained Apex Roofing to let them deal with it, meaning, you know, let them handle the claim and pursue the litigation. And the effect of a summary judgment in this case would preclude any payment under the policy for those additional living expenses. And so the insurance company wants to point to the language of the assignment and say that claim wasn't given to Apex Roofing to pursue as part of this lawsuit. I think based on the testimony, there's at least a fact question, or that it's not entirely clear that wasn't Mr. Shapiro's intent in giving them the right to any causes of action arising out of this claim. And so, turning back to Goldberg, you know, one of the issues in this case is understanding that there wasn't compliance with this pre-suit notice requirement. If a supplemental claim was required prior to filing suit, what is the appropriate remedy in this situation? And pointing to a number of cases from this court recently, talking about how a final summary judgment that results in a total forfeiture of coverage is not the appropriate remedy for premature litigation. You know, the insurance company didn't come to the trial court and say, look, we paid every dollar that we will ever owe on this case. There was, unlike Goldberg, there was at least a competing estimate that had been provided.
But in those cases, and I agree that, you know, it is not looked upon fondly to do forfeiture, but in the other cases, there's at least some sort of cooperation or explanation of why the insured did nothing. And so help me out with that. Where is that in this case?
Well, as far as cooperating with the claim investigation, I'd have to go back to the initial claim.
And that's all you have, right? Is the...
Well, so there's case law talking about the insurance company needing to establish a material and willful breach of a policy term in order to obtain summary judgment and a forfeiture of coverage. Here, there certainly isn't any evidence that this was, there was a refusal to provide a supplemental claim. In fact, once this issue was raised after suit was filed, the plaintiff's response to the summary judgment was, well, number one, there's a fact question on the actual cash value of the loss and whether the insurance company failed to comply with its obligations under the policy. But also on the other hand, my apologies, I lost my train of thought.
It's all right, happens to me all the time.
Understood. Well, so there was an estimate provided prior to the 3-year deadline in litigation. There's the Magrillos case versus Citizens, where this court has said attempted compliance after suit was filed can be considered at the summary judgment stage. So we have a situation where there is a fact question about whether the insurance company complied with its obligations under the policy, and whether the failure to participate in a pre-suit mediation, which is a non-binding confidential process.
But they didn't even know there was anything to dispute to even trigger the mediation, right? And if you talk about what their obligations are, I think it's section 627.7011, where it says when their obligation is to pay any remaining amounts, it's as the work is performed or expenses incurred. And they don't even know anything about this until well into the litigation. So where would be the breach by the insurance company?
15 minutes, just so you know.
The breach by the insurance company is the initial failure to adequately adjust the initial claim and to pay the actual cash value of the loss. The cases that talk about needing a breakdown in the claims process or a race to the courthouse, I mean, the concern from courts in those situations is the potential premature exposure to attorney's fees. The vast majority of those cases contemplate that the insured will still obtain a full recovery under the policy for the indemnity for the covered loss. And again, if we look at these provisions, the mediation or appraisal provision, the suit against us provision, there is nothing that says the failure to comply with these provisions will jeopardize or eliminate any coverage that would be available under the policy. It would simply make the lawsuit filed by the insured premature. The insurance company, you would expect, would raise that as either seek to compel abate the lawsuit to compel compliance with those post-loss duties, or it would assert the affirmative defense and prove up prejudice, and that simply hasn't happened here yet. And the Corinne case from the Florida Supreme Court really outlines the impact of a failure to comply situation as well as any other case does. I'll reserve the remaining time.
You'll have 3 minutes.
Thank you.
May it please the court. Brett Albrecht of Kubicki Draper on behalf of UPC. The defense summary judgment here should be affirmed.
Can I ask you a question?
Yes, Your Honor.
Rodriguez versus Avatar, one of our cases, basically says for there to be a total forfeiture of coverage under a homeowner's policy for failure to comply with post-loss obligations, the insured's breach must be material. Okay, so we have some conversation about maybe there wasn't any written notice, there was a telephone call or some oral notice. So the question really here is of materiality, because we know that a forfeiture of coverage is a severe, result, and the courts don't like forfeitures, so how is this material? I mean, why is this so monumental that it's almost insurmountable?
Your Honor, it was material because there was a total failure to comply with multiple policy conditions precedent filing a lawsuit.
Walk through them, set them out.
Yes, Your Honor. There were 3 separate policy conditions. Apex's counsel mentioned condition C, duties after loss. Those are post-loss obligations that are really not at dispute in this lawsuit or this appeal. The conditions at issue were number 1, the requirement to notify UPC in writing of any disagreement with UPC's initial claim decision. And that requirement was repeated twice in 2 separate conditions. The first was in the mediation or appraisal provision, which is condition F. And it provides that if you and we fail to agree on the settlement regarding the loss, prior to filing suit, you must notify us of your disagreement in writing so that either party may invoke mediation or appraisal. That requirement of written notice of a dispute is also contained in condition H, which is the suit against us provision or the no action clause. And so that requirement of written notification of a dispute is repeated twice. It's clear those are conditions F and H. The second condition that was violated, total noncompliance, is condition T, notice of claim, which required that the insured or claimant, here Apex as the contractor, submit a claim or supplemental or reopen claim for additional payment. That simply was never done here. On the date this lawsuit was filed, there was no supplemental claim or request for additional payment pending from Apex or anyone else. On the contrary, the initial claim from the insureds had been paid and the claim had been closed for over a year and a half. And in fact, on the date the lawsuit was filed, Apex had not even provided UPC with notice of its assignment of benefits contract.
Can you address counsel's statement that if we're looking at the policy under duties after loss, that the language in case of a loss to cover property, we have no duty to provide coverage under the policy if the failure, and then it goes on, that language doesn't exist in the other sections that you've just brought up?
And I would, yes, and if I may take a step back very quickly and just finish addressing Judge Morris's question about the 3 conditions, because I got the condition 2, and then I started going into detail. Just very briefly, and then I'll answer your question directly, is the 3rd condition was the requirement to submit to mediation or appraisal before filing the suit. And I'd like to get into those conditions in more detail. But first, with regard to the question as to the difference in the policy language, I think it's important that condition C, duties after loss, it recognizes that for a violation of those cooperation type agreements, that there must be prejudice. Now, the case law is clear that in the situation of a total failure to comply, and that I'm referring mainly to the 4th District's decision in Goldman versus State Farm, and there a total failure to comply should not raise an issue of prejudice at all. However, a partial compliance is going to raise an issue of prejudice, and UPC's policy recognizes that prejudice would need to be shown. In the case of the case law shows us that in the case of a partial compliance before suit, that the burden actually would be on the insured or claimant, here Apex, to show that the insurance company was not prejudiced. So I think it's important that the conditions we're dealing with in the policy, they don't say that prejudice is required before coverage would be barred. So the case law is clear that these conditions must be complied with. There was a total failure to comply here. And I just want to emphasize that UPC's position is that any issue or argument of partial compliance really was not raised or addressed below. We believe this is a total failure to comply with those 3 policy conditions at issue in this case. I do want to address some of the points that Apex's counsel made regarding the supplemental versus initial claim. It's very clear, looking even at this court's decision in Ironwood and also at the decision in Goldberg, as well as, of course, the policy language and controlling statute, that the claim by Apex here is a supplemental claim. And it was not actually made, if at all, until after the lawsuit was filed. I mean, I think it would be easier for us all to kind of conceptualize if we were talking about the very initial claim. If it just seems so obvious that an insured could not, or a claimant could not make an initial hurricane claim after filing a lawsuit on that claim. It's just, it really is putting the cart before the horse. The situation is no different when a supplemental claim is at issue. Now, in Ironwood, although Ironwood did involve a supplemental claim for a different type of damages, windows and doors as opposed to a roof, this court's decision did not say that a supplemental claim had to be for a different part of the property. And on the contrary, the statute at issue and the policy specifically defines a supplemental claim as basically a claim for an additional payment on the same loss. And that is what we have here. And the decision in Goldberg out of the 4th District confirms that also. And the Goldberg court also rejected similar arguments that Apex is making in this appeal regarding, Apex is trying to assert that somehow UPC should be precluded from relying on or enforcing its policy conditions because allegedly UPC underpaid the insured's initial claim. But those types of arguments were rejected by the court in Goldberg because the court just emphasized that there was no pre-suit estimate. And for policy conditions requiring certain things to be done as a condition of filing suit, condition precedent to filing suit, that has to be enforced by looking at whether the conditions were complied with at the time the suit was filed. And in this case, there was a total failure to comply. So I'm just looking through my notes. I want to make sure I don't miss any points. I wanted to mention the ALE claim is under a completely separate coverage. That is coverage D. Apex's claim and Apex's assignment of benefits contract is for services rendered or to be rendered, which is for basically repairs to the building or dwelling, which is coverages A and B. So the assignment does not extend to ALE. That still belongs to the insured, and suit was never filed on coverage D. So UPC's position is that is just a complete red herring, and it doesn't have any bearing on the arguments. The premature lawsuit arguments, the suit here is more than premature. A supplemental claim was not made before this lawsuit was filed. UPC's position is that receiving notice of the assignment of benefits contract for the first time after a lawsuit is filed, receiving the $500,000 estimate roughly 10 months after the lawsuit is filed is no better than never receiving the competing estimate at all. And it's very important. UPC recognizes that this court does have decisions, where this court has explained that generally the remedy for a premature lawsuit is abatement. But again, this lawsuit is more than premature. In the vast majority of this court's decisions and other courts' decisions that have held a lawsuit to be premature, there has been either a partial compliance with the policy conditions or a pre-suit estimate provided before the lawsuit was filed. The one exception would be the decision mentioned by Apex's counsel, and that is the Macrolos versus Citizens case. But that case is still very different. That involved a sworn proof of loss form that was requested by the insurance company. And it was provided after suit, as this court noted in its decision. However, the very important distinguishing fact there is that the insurance company's attorney told the insured in a letter that he could just bring the sworn proof of loss form to his examination under oath, which ended up getting rescheduled such that the proof of loss was late. So even in that situation, there are very important distinguishing facts. This case is on all fours with the 4th District's decision in Goldberg. Goldberg has already addressed and rejected similar arguments to those raised by Apex here. The trial court did not err by relying on Goldberg. And so, Your Honor, UPC would respectfully request this court to affirm the final summary judgment in favor of the defendant below. Thank you, Your Honor.
Thank you very much. You have 3 minutes, sir.
Thank you. A couple of brief points. First, Again, Goldberg is not on all fours with this case. And the order under review in that case specifically said that nothing in its ruling would prevent the Goldberg from filing a supplemental claim under the policy. So yes, the court entered final summary judgment on that lawsuit, but it did not result in a total forfeiture of coverage because of the timing of that order. There was no indication in that case that the plaintiff had submitted a competing estimate. So at the time the court is considering the summary judgment ruling, there's no fact issue as to whether the insurance company had paid the full amount of its competing estimate. Counsel mentioned that the issue of partial compliance was not, prejudice was not raised or addressed below. Their fifth affirmative defense tracks the language of the section C conditions that could be the only affirmative defense upon which they were moving for summary judgment in this case, and prejudice was a factor in their analysis. Finally, the argument that the request for abatement came too late. Recently, this court in the Iwaniki case encountered a ruling on a motion for directed verdict, where the trial court had held that the lawsuit was filed prematurely. And on appeal, this court recognized that even at the directed verdict stage, entry of a final judgment resulting in a forfeiture of coverage, it isn't appropriate when the allegation is simply that the lawsuit is premature. There's a difference between saying, I haven't breached the contract yet, and I didn't breach the contract. And that's the position that we're raising in this case. And we believe that based on this record, that's a fact question for the jury. So if there are any questions, then we would ask that you reverse and remand for further proceedings. Thank you.
Thank you both very much. You both did a great job today. Our next case is Gary Roberts and Associates versus Clark and Martino.